Okay. Can you hear me, Judge?
I certainly can, Mr.
Okay.
Happy Groundhog Day.
Happy ground, yes. So they're bringing, I think they're bringing Mr. Brissett.
Jeremy Brissett.
Yeah, Brissett. But when I got here, the computer wasn't logged in, so they had to find somebody to, set it up and all that.
Sometimes that's a task.
Are you Mr. Brissett? Yeah. Okay, come over here and have a seat. Okay. There you go. There you go. Have a seat right there. Is Mr. Brissett your honor?
Morning, Mr. Brissett. For the record, is your full name Jeremy Thomas Brissett?
Yes, sir.
Matter is set for arraignment on the 4 new charges and sentence compliant hearing on a previous matter. I'll refer to Mr. Haverco. I'm appointing him to represent you on these the new matters as well.
Thank you, Your Honor. So I had an opportunity to discuss with Mr. Brissett his new case, his arraignment case, and we had an opportunity to review the police reports that form the basis of the charges. We also reviewed what an arraignment is, and he would like to waive arraignment. We do acknowledge, he understands his rights. He understands he has a right to enter a not guilty plea, and he understands the maxims that can be imposed. He'd like to proceed with entering a statement of defendant on plea of guilty, which I've reviewed with him. And the form is prepared where he would be pleading guilty to two counts, and the city would move to dismiss 2 counts. And recommendation is basically a time served recommendation. I've explained to him too, the judge doesn't have to follow it. So anyway, we'd like to proceed with that.
Mr. Brissett, do you disagree with anything Mr. Haverco just said?
No.
You do have a right to be arraigned, enter a plea of not guilty. You have a pre-trial. Mr. Haverco informs me that he wants to proceed to disposition on your behalf at this time, and that's with your at your direction. Correct?
Yes.
I'm looking at a statement of defendant on plea of guilty to 2 counts of possessing dangerous knives. Also, the understanding that the other 2 counts, plea form tells me you're 46 years of age. Any problem of understanding the plea process?
Yes, sir.
Have you gone over the plea agreement with your attorney?
Yeah.
You realize if I accept the plea, you give up the rights contained in paragraph 5, no trial, no appeal, simply a sentencing, which could be up to 90 days in jail and or 1,000 on each regardless of what's recommended. You realize that?
Yes, sir.
I do find your statement in paragraph 11 to satisfy that does satisfy the factual elements of the offense. I'll ask you as to 2 counts of possessing dangerous knives occurred within the city of Yelm on December 9th, 2022. How do you plead guilty or not guilty?
Guilty.
Take that plea of your own free will.
Yes, sir.
Anybody make any threats or promises to you to make you plead guilty?
Yes, sir.
I'll find the plea to be freely, knowingly, and voluntarily. The recommendation, Redfield, anything to add to that?
No, nothing, Your Honor.
Mr. Brissett, anything you wish to tell me? Now you have a right to tell me anything you wish regarding the matter. Now's the time. You don't have to say anything, but if you have anything to say, now's the time.
I just wish I could get all this wrapped up into one thing and get it all taken care of so I can get done and on with my life. All these other things too,
Mr. Brissett, I'm going to follow the recommendation. It sends you to 90 days in jail on each count. All jail time is suspended on the condition you have law-abiding behavior.
For sure.
It's sure we both know what leads you to find yourself in custody on a very time. If you don't put that stuff down, it's eventually going to get, you know that, I think.
For sure.
I'm not going to make any orders with respect to that. The condition of the suspended sentence is law-abiding behavior.
Treatment.
The matter does come back. You will get credit for any time you have served in connection with the matter.
Thank you.
Is there any agreement with regard to the sentence compliance hearing? City taking any action on that at this time, or Mr. Brissett, you do have suspended jail time on your other case. This just adds another to that. Stay out of trouble. I'm going to wish you the best of luck. You take care of yourself, and I think you know what you need to do to take care of yourself. Any questions?
For sure. No.
Good luck.
Thank you.
Thank you, Your Honor.
Sure. What's going on?
The custody officer.
You'll get done. You should get out there.
And I should say for the record, given the indigency of the defendant, no fines imposed. Sir, I feel if you'd sign off on the JNS form.
Okay, good. I see. There you go. Morning, Your Honor. This is Mr. Ray Bauman. He's number, what is he, number 6 on the 8:30 calendar for arraignment, I had an opportunity to discuss with him the case, or had an opportunity to review the police report, and he'd like to proceed with the statement of defendant. I'll plead guilty this morning. We discussed what an arraignment is, to be advised of his rights, to be advised of what the charges are, the nature of the elements, what the maximums are, and we discussed what those are. So he understands those, but with that understanding, he'd like to proceed with entering a plea. He has a disagreement. He has a different version of what he feels is a correct characterization of what the facts are. We discussed, however, the police report. And the reason he's entering a plea, he's going to do it by way of an Alford plea. And he's entering that plea because while he doesn't necessarily agree with the purported evidence in the police reports, he feels that if the matter were to go to trial and the city were to present its evidence, along with whatever evidence Mr. Ray Bauman might present, that it's fairly likely, highly likely, that a fact finder, whether it be a jury or a judge, would make a finding of guilt. Because of that, he wishes to enter a plea to also take advantage of the city's plea offer, which is time served, and so that's what we're asking to do.
The record is your name, Sean Charles Ray Bauman. Mr. Ray Bauman, take your nod as a yes. At all that Mr. Haverco just said.
Yes.
Do you agree with him?
Yes. I'll take it here.
Just speak up a little bit. Yeah.
I am appointing him to represent you in this matter. What I need you to do is answer verbally instead of nod. Say yes or no when I ask you a question, if you would. Or if you don't understand what I'm asking, ask me to clarify things, okay?
Yes. Yes.
I am looking at a statement of defendant on plea of guilty to one count of theft in the 3rd degree and one count of criminal trespass 2nd degree, amended down from 1st degree. The plea form also indicates there's going to be a dismissal of the resisting charge if the plea is accepted. Do you disagree with that?
No, I do not disagree with that.
Have you gone over the plea form with?
Yeah.
You need to answer yes.
Oh, sorry. Yes.
And if you had any questions, were they answered?
I can't.
He was asking you, did I answer all your questions?
Yes.
If I accept the pleas, you give up the rights contained in paragraph 5. There's no trial, no appeal, simply a sentencing, which could be up to the maximum regardless of what's recommended. You realize that?
Yes.
With that in mind, as to one count of theft in the 3rd degree and one count of criminal trespass 2nd degree alleged to have occurred within the city of Yelm on December 14, 2022. How do you plead, guilty or not guilty?
Guilty, Your Honor.
Please, of your own free will.
Guilty, Your Honor.
Anybody make any threats or promises to you to make you plead guilty except the sentencing recommendation?
No.
I will find the plea to be freely, knowingly, and voluntarily made. Now, I understand this plea is made pursuant to the provisions of State v. Alford. It's an Alford plea, which means you're not admitting to anything specifically, but you have gone over the police reports with your attorney, and you wish to take advantage of the plea agreement and agree that if the matter were to go to trial, there'd be a high likelihood of a guilty finding by a trier of fact. Is that pretty much the case?
Yes.
Mr. Hatfield, anything to add?
Nothing, Your Honor.
Mr. Haverco, anything to add?
Nothing, Your Honor.
Mr. Ray Bauman, is there anything you wish to tell me? Now's the time to speak. If you have anything you think I should know, you don't have to say anything, but if you want me to know anything, now's the time.
I was willing to pay for it in a dollar amount and apologize to the store clerk.
I'm not gonna accuse you of anything. I am gonna follow the recommendation, but I
Okay.
suspect, and again, I've reviewed the police reports at the time I spoke to you when you were arrested. And I do find there's a sufficient factual basis for the pleas. And I suspect that perhaps some substance you'd ingested at the time of the offense may have made the situation a little like it turned out to be. What I want you to do is keep in mind that the jail time is going to be suspended. That's 364 days with regard to the theft charge, and 90 days with regard to the criminal trespass second degree charge. That jail time is suspended, and you will get credit for time served if the matter comes back before me. The jail time is suspended on the condition you have law-abiding behavior. That includes not going places where you've been trespassed from. That sounds simple enough. You know, what you do on your own time is your own business, pretty much, but you need to make sure you don't inflict yourself on other people or other businesses when you're living your life, okay?
Yes, sir.
Unless there's another hold on you, you'll be released from jail today. I'm going to wish you the best of luck, Mr. Ray Bauman. But again, you only find yourself in front of judges because of what you do. You know, stay out of trouble, and you won't have to listen to me talk to you. Okay.
Okay, sir.
Right, Mr. Bauman, Ray Bauman.
You too, sir. Have a great day.
Thank you, Your Honor.
For the record, no fucking. Good morning, everyone. Is your attorney going to be here in person or on Zoom? Oh, good. We'll wait for her to arrive. First things first. First things first. The kids need to be taken care of.
Yes, I get all the buses at 6 o'clock. They're like, we sleep on. I just live in Roy, it's less than an hour and 20-minute drive to their high schools.
Oh, boy.
I think they should have a high school in Roy. So many children in Roy, they can have a high school out there for people.
One of these days, one of these times. Budgetary concerns, et cetera, et cetera. That's.
I know.
Doing okay, period.
Morning, Judge. This is Gerald Christopher. He's item numbers 3 and 4, which shows arraignment. I went into the docket, the case actually, that's docket number 3. It's actually a pretrial hearing. He actually was arraigned on that. It just somehow showed up as an arraignment, but so he is here for arraignment on the new case, and I had an opportunity to speak with Mr. Christopher in the jail, and he understands what an arraignment is, and right to be read, his rights and the charges and the elements, the nature of the charge and the maximums that can be imposed. And he understands all that. So he wants to waive arraignment and go ahead and proceed on both matters and try to take care of those today. And I prepared a plea form. Yes, and which I reviewed with the defendant, and I believe he understands what's in the form, and I'd ask your honor to inquire.
Good morning, sir. For the record, is your name Gerald, middle initial F, Christopher?
Mhm.
Mr. Christopher, if you say yes or no instead of not, I'll take your nod as a yes, but if you just say yes or no,
Yes, yes, Your Honor.
that would be very good. I'm looking at a statement of defense, a plea of guilty to one count of theft in the 3rd degree, which involves the plea form involves a dismissal of a second charge of criminal trespass in the 2nd degree. Plea form tells me you're 29 years of age. Have you gone over the plea form with your attorney?
Yes.
Yes, Your Honor.
And if you had any questions, were those questions answered?
Yep. Yes, Your Honor.
I accept the plea. You give up the rights contained in paragraph 5. There's no trial, no appeal, simply a sentencing, which could be up to the maximum 364 days in jail and or a $5,000 fine. If I accept the plea, you realize that.
Yes, Your Honor.
With that in mind, as to one count of theft in the 3rd degree alleged to have occurred within the city of Yelm on May 19th, 2022. How do you plead guilty or not guilty?
Guilty.
You make that plea of your own free will.
Yes, I did, Your Honor.
Anybody make any threats or promises to you to make you plead guilty?
Yes, he said I'd be getting out today.
They
You promised that, yeah.
knowingly and voluntarily made, and your statement in paragraph 11 on the plea form does have the factual elements of the offense. I've heard the recommendation as to sentence, Mr. Hatfield. Anything to add? Nothing further to add. Mr. Averco, anything to add?
Nothing, your honor. Ask the court to follow the recommendation.
Mr. Christopher, anything you'd like to tell me? Now's the time. You have the right to let me know.
That one, yes, I do have something I want to tell you. That one charge that you asked me about, that from Thurston County, it was dropped because I didn't do it, not dismissed.
Okay. It's good to know that. Mr. Christopher, you keep getting in trouble and you keep failing to appear in court. That's why you're being held on very little bail. This is the only way I could possibly conceive of getting you before the court.
You remember what charge I was talking about in Thurston County that you made me announce out loud? Can you please state the charge that I was talking about?
Yep.
Can you say it out loud?
Mr. Christopher, on this charge, I'm going to follow the recommendation. 364 days in jail, all suspended on the condition you have law-abiding behavior. That's the
Yes,
only
Your Honor.
law-abiding behavior. Stay out of trouble. Stay out of trouble and you won't be back where you are right now. I don't know what else to say to you except that. And if you happen to find it necessary to come to, you need to go to court, just show up. Just show
All
up.
right.
Your trip to the jail, okay?
Well, your officer kind of threatened me with the flashlight and like he was going to hit me with the flashlight and stuff. I'm kind of scared of your officers, Your Honor. They're kind of like very threatening.
If you have a complaint to file against any officer, you can file a complaint with the city.
Yeah, the arresting officer like threatened to hit me with the flashlight, but like I don't want to file a complaint.
I'm going to leave that up to you. I'm going to wish you the best of luck. Unless you have some other hold on you, you'll be released on this hold. Okay?
All right, thank you, Your Honor.
You take care of yourself.
Thank
I
you.
will.
Thank you, Judge.
Thank you so much, Your Honor. You have a great day.
And
God bless.
Take care.
You guys are gonna take them off, but your guys are gonna bring them.
No. Going out of here today?
Yeah.
All right.
So, so I'm gonna go back to the courthouse and the custody officers are going to bring Trey Jones.
Ray Jones, is the last one, yes.
Yeah, but I'm gonna take off now because he's just a compliance diversion case, so.
He's being held on apparently a Lacey charge. That's why.
Oh.
That's all.
Okay, so I'll.
The compliance issue. That's why Lacey probably has their hands full.
Okay. Okay.
Brought up. Back on record, call the matter of Yelm versus Crystal. You're right. Ms. Bowden, good morning.
Good morning.
Fury, good morning. Matters at the pretrial status. I'll defer to the parties for the status of the matter.
You know, we've reached an agreement in this matter. The DUI is being amended to a negligent driving and we are entering a plea of guilty. There are 2 reckless endangerment charges. One of them is being dismissed. The other is being put on a 12-month SOC. I have gone over this with my client. I believe she's making a knowing and intelligent decision. She's also completed her evaluation and her victims panel, which is scheduled for ADIS.
Perfect. The record is your full name, Crystal Ann Fiore.
Yes.
If I mispronounce your name, I apologize.
No, you actually counts in pretty.
Thank you. I'm looking at the statement of defendant on plea of guilty to 1 count of negligent driving in the 1st degree, amended down from driving under the influence. Plea form tells me you're 43 years of age. Have you gone over the plea form with your attorney? And if you had any questions about what it meant to enter a plea of guilty to this charge, was your question answered?
Yes.
Now, if I accept the plea, give up the rights contained in paragraph 5, no trial, no appeal, simply a sentencing, which could be up to the maximum 90 days in jail and or $1,000 fine, this being a simple misdemeanor. You realize that?
Yes.
Now mine as to 1 count of negligent driving in the 1st degree, alleged to have occurred within the city of Yelm on October 26, 2022. How do you plead guilty or not guilty? You make that plea of your own free will.
Yes.
Anybody make any threats or promises to you to make it plead guilty?
No.
And we'll find the plea to be freely, knowingly, and voluntarily made, and your statement in paragraph 11 on the plea form, I find does satisfy the factual elements. I've read the recommendation as to sentences. Mr. Bradfield, anything to add? Ms. Bowden, anything to add to the recommendation?
No, Your Honor, it's just my client is on a fixed income. She does have some teenage daughters that apparently are getting Social Security. She's this shouldn't have happened, and I don't think it'll happen again. So I think the recommendation is fair. She is going to need a time payment, but.
And the recommended fine is there a recommended?
I think it was $250 on the note.
Ms. Fury, anything you'd like to add? Anything you'd like to tell me? You have what they call a right of elocution. You can tell me anything you think I should know. You don't have to say anything. You can rely on your attorney's.
No, I think she stated everything very clearly. I am on a fixed income. We do have EBT and medical, from the state. And I'm single mom, so.
I'm assuming the evaluation that was part of the plea agreement, I assume that costs something to
Yes.
do it. Always does.
You know, we'll get that filed. They're trying to go electronically in my office and I'm still fighting, wanting to do paper, so I have everything.
Being a cyber dinosaur myself, I'm struggling and all is well with the transition from the paper world to an electronic world. Ms. Fury, I'm going to follow the recommendation, 90 days in jail, all suspended, mostly on the condition of law-abiding behavior. We'll talk more about that when we address the other matter this time. The first charge, ticket ending in 760, is dismissed as part of the plea bargain. The fine will be $250, which you can pay. We'll set the payments on that at $25 a month. Now, the fine is the least important thing to me. If there's an issue making the fine payments, just let your attorney know, and that is something we can pretty easily deal with in terms of community service. Where you've got, I'm aware of from the file, the ages of your children, and yes, that's a lot of expense, a lot of parental worry, a lot of the parental involvement in their lives. They have to come first. So if there's a problem with the fine, let us know. Signing electronically, we sign everything these days. I'm signing the plea agreement as we sign, as we speak.
Always curious.
Bit of a three-stage process. So
Just go ahead and tell me when.
the judgment of the sentence. Soon as that's, well, we'll have that served on you. When we're done, Ms. Fiore, you can get a copy of all today's papers out the window outside the courtroom and to the left, and review them carefully. And if you have any questions, give your attorney a call. Okay.
Your, the signature pad isn't signed in.
Oh, that's
Oh, well, okay. She'll just have to sign. We'll just, we
we'll
just,
just, yeah, that's. Check the boxes, check served on defendant, so yeah, get a copy of everything. Ms. Fiore, I'm now looking at the stipulated order of continuance. This is with regard to ticket ending in number 761. I'll defer to your attorney for the presentation of that matter.
Your Honor, in that matter, we are entering into a stipulated order of continuance. She understands that for the next 12 months, she's got to have law-abiding behavior, no similar incidents. Complete all her affirmatives for the negligent driving. And there's $100 fee on that. And she understands that she will, part of the agreement is that she pays that. If she complies with all the conditions, she understands that discharge will be dismissed.
Ms. Fiore, these are pretty much of a form thing. What they are basically is a contract between yourself and the city negotiated by your attorney, under the terms of which, if you comply with the conditions, charge is dismissed. If you violate the conditions and the city proves that, we'll have a hearing based on basically the police reports, and you know what the finding would be on that. That would subject you to a significant amount of jail time and a fine. That's you've got a fair amount at stake here with regard to the first charge of DUI. You've got a tremendous reduction of that, as I agree, and I think your attorney would agree with me. A DUI conviction is worse in terms of impact on your life than a lot of felony conditions. You've got a pretty good break there. The biggest break you got, in my opinion, is the fact that you're sitting there and you're healthy and your children are healthy as well. One of the cases I was involved in years ago as a defense attorney was a gentleman who didn't really care how much jail time he was looking at, because the person who died in the accident caused by the drinking was his wife, who had been sitting beside him in the car. That's where this goes eventually. Hopefully it's been a very significant learning experience and one in life not to be repeated at all. All I can do is look forward to dismissing the reckless endangerment charge a year from now, hopefully to find you in fully compliant with the terms of the agreement and your sentence. So I'm going to wish you the best of luck. That's about all I can say. We learn from our mistakes, so we're condemned to repeat them, as is often said. Ms. Bowden, good to see you. You
Nice
take care
to
of
see you
yourself.
too.
Ms.
Thank you.
Fiore, I wish you the best of luck. You take care of yourself. Take care of your children.
I will.
They're going through those teen years, which are a trial to them and you as well. Good luck.
Thank you. Thank you very much.
Happy Groundhog Day, and take care. Today is. I think that means, 6 more weeks of winter. That's never accurate, by the way, but that's the prediction. Ian, when you're ready to go, we'll address your matter now. Call the matter of Yelm versus Michael Arneson. Mr. Arneson is here, represented by his counsel, Mr. Kean.
Good morning, Your Honor. And we do have a resolution to present to the court. The city would be amending to disorderly conduct, and Mr. Arneson is requesting the court enter a stipulated order of continuance. I've reviewed the stipulated order of continuance form carefully with Mr. Arneson. I believe that he understands both the upside and the downside of the contract, that he has the ability to earn a dismissal by payment of $200 in court costs in 12 months without any criminal law violations. On the other hand, if he violates the agreement, he would be back before the court for a stipulated bench trial where the only evidence would be the police reports. And it's a very high likelihood that the court would return a verdict of guilty after reviewing those police reports. So Mr. Arneson's 21 years of age with a spotless record. This is an opportunity for him to continue along that path. And it's a great opportunity for him. We're really grateful to the city for extending this.
Mr. Arneson, for the record, your name is Michael, middle initial W. Arneson. You disagree with anything Mr. Kean just said? Do you disagree at all with anything your attorney just said? He has negotiated on your behalf a contract, basically, between you and the city, under the terms of which he's done the best he can do. He's put you in a position where this can get reduced to a much less serious charge, but the rest of it is up to you. You've got to comply with the conditions. The conditions are most significantly no law violations. Stay out of trouble. And also there's a $200 cost that is to be paid. If you abide by that over the next year, the charge will be reduced to a much less serious charge of disorderly conduct, and will go on your record as such. Your attorney's put you in a position where, hey, if you've learned from this and if you don't reoffend, you get the benefit of the contract, a much less serious charge. Any question at all?
Well, Your Honor, I'm sorry, a point of clarification. I believe that
Yes.
with the SOC, the offense is first being amended to disorderly conduct,
Yes.
but but following the 12 months, it would be dismissed at the end of 12 months.
Well, amended at this time to disorderly conduct. Okay. I misunderstood. I've got the agreement on a screen here. But yes, the charge is being amended now to the less serious charge of disorderly conduct. Still, violation of the agreement would be a criminal offense and result in a conviction for the amended charge. Mr. Arneson, I'm going to wish you the best of luck. You take care. We either learn from our mistakes, as you heard me say a moment ago, or we're condemned to repeat them. Your attorneys put you in the position of walking away from this situation with minimal damage. I'm going to wish you the best of luck. Take care. The $200 costs, you can pay at the rate of $25 a month now. Okay. And again, you'll get a copy of the agreement at the window. I want you to review it carefully, and if you have any questions at all, give your attorney a call, okay? Good luck to you, sir. At the window outside the courtroom and to the left, and you'll be able to get a copy of the agreement as well. Your attorney will help you.
And thank you very much, judges.
Mr. Gill, thank you. When you're here for I'm assuming everybody that's here is here for either a 9:45 hearing or a 10 o'clock pretrial. Your attorney is present in the courthouse, and he'll be with you when he's able to do so. Is Andrew Bench in the courtroom?
He's on Zoom.
Oh, he is on. Is he?
He lives next.
Okay. How about Nicholas Rakers? Mr. Rakers? Let's take that. Let's take your matter. You missed a pretrial hearing. A warrant was issued. What's the situation?
Unfortunately, I have to say ignorance. I had lots of work going on. I couldn't get an attorney scheduled after my initial attorney dropped me. I now have retained counsel, which will be here for any further hearings. I retained him last night. He wasn't able to make it today.
Okay, why don't we will let's set the matter for a pretrial conference down the road. Now, since your attorney's not here today, he may have a conflict with regard to the time we're gonna set. So let him know as soon as you can. When the pretrial is, and that will be probably March. We'll set it for March 2nd. Now, we're going to prepare an order. That'll take a minute to do that, but you'll get a copy of the order at the window outside the courtroom to your left. And let your attorney know that March 2nd is the date scheduled, and if he needs a continuance, he can give us a call. He'll know. He or she will know.
Coming to quash this warrant today.
Yes, warrant is quashed.
Does that help? Does that relieve the hold on my license from Yelm?
That's up to, you need to talk to your attorney about that. Yeah, we're gonna lift the warrant, but that's something you need to talk to your attorney about.
Okay.
March 2nd, 9 o'clock. Mr. Eggers, you can get a copy of the order today at the window outside.
Okay, thank you.
Mr. Bench is on. He's on Zoom. Go ahead and bring him up. Mr. Bench, are you able to hear me? I see you may have just unmuted yourself. Good morning.
Good morning. Hello, I can hear you.
Is your name Andrew Tim Bench?
Correct.
Mr. Bench, you're in warrant status for failing to appear at an arraignment. This goes back to a 2017 case. It's got a little age on it, but we'll arraign you at this time. Citation alleges that on or about May 20th, 2017, you committed the offense of theft in the 3rd degree. Theft in the 3rd degree is a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. You have a right to have a lawyer represent you. Mr. Haverhill, our public defender, is in the courtroom now. I'm going to have him enter a plea on your behalf at this time, and he will represent you throughout the duration of your case. Should you prove to be indigent, that's something Mr. Haverhill will discuss with you and your request of services. Mr. Haverhill, please.
Thank you, Your Honor. And if I may ask, which case was this?
This is page 6, docket number 1, warrant quash and
ma-
arraignment at the same time.
Oh, is that Andrew Bench?
Yes.
Okay, thank you. So it's a theft charge, would stipulate, Your Honor, would stipulate to probable cause as the court to enter a not guilty plea.
Mr. Bench, a plea of not guilty has been entered on your behalf. That preserves your rights. We're going to set the matter for a pretrial. The stipulation to probable cause just means that it's agreed that there's sufficient legal basis to issue you the citation. Long way from proving that you committed the crime by evidence beyond a reasonable doubt.
And if I could just mention to Mr. Bench, usually these are done, in person. And so if you're here, I would be asking you for your phone number. But could you just make sure to leave a message as soon as you can on the phone number provided in my assignment letter and leave your number so I can call you back. Thank you.
Mr. Bench, you're appearing by Zoom. For your next court appearance, were you planning on being here in person or appearing by Zoom?
By Zoom preferably. I just live out of state currently.
Well, Mr. Abaco, did you hear what he said? He doesn't know how to contact you as we speak now, and I don't need to hear your telephone number. We're going to mail you an order setting a pretrial date that you can attend on Zoom. And the order will have the contact information with Mr. Haverco, and he needs to hear from you. He needs to be able to contact you as well. So the minute you get this, give him a call at the number on the form and let him know what your contact information is, email, telephone, what have you. Okay.
Okay. I also posted it in the direct chat as well. So.
Okay. Hey, we apparently have that. That'll be given to Mr. Averco. Good luck to you. Thank you for appearing. That concludes the hearing today. We'll send you a copy of today's order. Then the hearing is set for March. When do we go to March 16th? Give a little extra. Oh, March 2nd is fine. March 2nd is your hearing date. Mr. Bench will 10 o'clock in the morning. We'll talk to you then. Take care of yourself.
Thank you, Judge.
You can sign off. Good morning.
Good morning, Judge. On the 10 o'clock calendar, item number 1, Diana Baywall, she's seated beside me, present for court. Matter comes on for a pretrial hearing. I've had an opportunity to discuss her case with her. It's our intention to enter a plea this morning. I've filled out a statement of defendant on plead guilty with her. I've reviewed what that is. I think she understands it. I've had her sign the form this morning and we ask Your Honor to inquire.
Good morning, ma'am. For the record, and I hope I don't mispronounce your name. Is your name Diana, middle initial J? Bawal? Bawal? How do you
It
pronounce?
was Baywal, it's Baywal.
Baywal.
Now it's Ocampo.
I apologize for, I'm looking at the statement of defendant on plea of guilty to one count of violating the terms and conditions of a protection order. Plea form tells me you're 37 years of age. Any difficulties at all in going through the plea form with your attorney?
No, Your Honor.
And if you had any questions, were your questions answered?
Yes, Your Honor.
If I accept the plea, you give up the rights contained in paragraph 5, no trial, no appeal, simply a sentencing which could be up to the maximum, which would be 364 days in jail and or a $5,000 fine. And that could be regardless of what is recommended by the parties. You understand that?
Yes, Your Honor.
With that in mind, as to one count of violating the terms and conditions of an order of protection alleged to have occurred within the city of Yelm on November 30th, 2022. How do you plead guilty or not guilty?
Guilty, Your Honor.
You make that plea of your own free will. Anybody make any threats or promises to you to make you plead guilty?
No, Your Honor.
I'll find the plea to be freely, knowingly, and voluntarily made. And your statement in paragraph 11 does satisfy the factual elements of the offense. Recommended sentence is all jail time suspended on the condition of law-abiding behavior. And pay a probation fee in the amount of $250. Mr. Travico, anything to add to the recommended sentence?
Nothing to add, Your Honor. I'm speaking with her. She's been through a lot and, so she, is glad to get this matter over with and move on.
Mr. Travico, anything to add to this? Ms. Baywell, anything you have to tell me? Now's the time. Do you have a right to let me know anything that you think I should know with regard to the matter? You don't have to say anything, but anything you think I should know, now's the time.
Nothing, Your Honor. Thank you.
I'm going to follow the recommendation, all jail time, 364 days suspended on the condition you have law-abiding behavior. The laws really takes these protection orders seriously, whether it's consented to or not consented to. It's kind of a serious matter. Hence, it's a gross misdemeanor, bearing the possibility of a lot of jail time. I'm going to wish you the best of luck. Yeah. And the jail time is suspended on the condition of the probation fee, which is to me fairly unimportant. And also that you have law-abiding behavior, which most importantly includes abiding by any and all no contact orders until they're modified by the court that enters.
There's a few documents you have to sign. Okay. That's one.
This paywall is a result of the conviction. Your right to have a firearm is suspended if that's important to you until it's restored by a competent, court of competent jurisdiction.
I did not get what you said, Your Honor. Can you please repeat it?
Pardon?
Something about my identifier?
Guns, firearms.
Oh, okay.
It's if you have any, you're not to have firearms in your possession next year. That's important to some people, but not to others, and I think that's includes you.
Wait a second. Not yet.
Oh.
Go ahead.
Excuse me. This paywall, paperwork generated in connection with today's hearing. You get a copy of that at the window outside the courtroom if you're left. I'm going to thank you for appearing and I'm going to wish you the best of luck. You take care of yourself, okay?
Thank you, Your Honor.
Don't go yet.
Thank you.
Thank you.
That's it.
Nope, not yet. One more. Here, go ahead. I think I had Ms. Baywell sign everything that was to be signed. There was one form that didn't seem to have
I
a
think
signature on it.
it's just the order sentencing. I think
We
that's
signed the JNS.
I think that's it. Ms. Baywell, again, I'm going to wish you the best of luck. You take care of yourself and have a great day.
Thank you, Your Honor.
Good
Thank
luck.
you.
Thank
Take
you.
care.
Mhm.
Good luck.
Thank you.
Anything further for the record at this time?
Like the next matter would be on the 10 o'clock, number 5, Jet Powell.
Good morning, sir. Full name, Jet Powell.
Yes.
Defer to your attorney for the status of the matter at this time. I'm looking at the SOC on the computer screen, Mr. Haverko.
That's correct, Judge. Matter comes on for a pretrial hearing on a malicious mischief. So the parties are proposing the court accept a stipulated order of continuance, terms of which are in the proposed order and ready to proceed.
Mr. Powell, an SOC is basically a contract between yourself and the city negotiated by your attorney under the terms of which, if you fulfill the conditions set forth in the agreement, at the end of the period of the agreement, 12 months, the charge will be dismissed. If you violate the agreement and the city proves that by a preponderance of the evidence, we're back to square one. We'll have a hearing based on the police report, and that would most certainly, almost certainly result in a conviction for a pretty serious offense, and which bears a possibility of jail time. I see there's no probation fee entered in the agreement.
I'm sorry, Judge, I missed that. I can insert that. Should have been a $250.
$250.
Yeah.
We'll set the payments on that at $25 a month. Mr. Powell, if there's an issue making the payments, just let us know. Get a hold of your attorney. We can easily deal with that. The most important thing is the law-abiding behavior part of this. No criminal law violations. Okay? Good luck to you. I'm hoping that in a year we'll be able to simply review the file, dismiss the charge, and close the case. Good luck to you.
Thank you.
Now, what I want you to do is get a copy of today's agreement. Read it over carefully, and if you have any questions, Mr. Haverko, give him a call.
No,
Oh, no, we're good.
you're good.
All right, thanks.
Good morning, sir.
One second. So on the 11 o'clock, this is number 5, Jose Malara. And I've had an opportunity to speak with,
Laura, good work.
had an opportunity to speak with Mr. Malara and his intention on entering a guilty plea, and I've gone over what that is with him and the rights that he gives up and so on, and ask the court to inquire.
For the record, is your name Jose Mario Malara?
Yes.
If I mispronounce your name, I apologize. Mr. Malara, I'm looking at a statement of defendant on plea of guilty to 1 count of operating a vehicle without ignition interlock when that was required by the Department of Licensing. Plea form tells me you're 52 years of age. Any problem reading, understanding the plea form? And have you gone over the plea form with your attorney? Yes. And any question you had about the process, was that question answered?
No, the only question is if I pled guilty of the interlock on the car, you were suspending more time my license at the DOL.
The part of the plea process here is an agreement to dismiss that charge, the driving license suspended charge, and that will take place if the plea is accepted. Now, if I accept the plea, you give up the rights contained in paragraph 5, no trial, no appeal, simply a sentencing which, since the charge you're pleading to is a gross misdemeanor, maximum penalty would be 364 days in jail and or a $5,000 fine, which I would be free to impose regardless of what's recommended. You realize that. With that in mind, as to 1 count of operating a motor vehicle without ignition interlock alleged to have occurred within the city of Yelm on December 26th, 2022, how do you plead guilty or not guilty? You make that plea of your own free will.
Yes.
Anybody make any threats or promises to you to make you plead guilty? find the plea to be freely, knowingly, and voluntarily made, and your statement in paragraph 11 does satisfy the factual elements of the offense. Mr. Aberco, anything to add to the?
Nothing to add, Your
recommendation?
Honor. Ask the court to follow the recommendation.
Mr. Redfield, anything to add? Mr. Villara, anything you want to tell me about the situation? You don't have to say anything, but if there's anything you'd like to tell me, now is the time.
No, Your Honor.
Okay. I'm going to follow the recommendation, all jail time, 364, suspended on the condition you have law-abiding behavior, no criminal law violations, and that would of course include don't drive unless you're equipped with ignition interlock, if that's required by the Department of Licensing. Sometimes there's all these hoops that you need to jump through, and this ignition interlock, that's just one of them. I'm going to wish you the best of luck. You take care of yourself. Matter is also set for a review of the diversion. City taking any action at this time on that? It looks like there's still some money owing on that, and as well, we're adding a $250 probation fee on this one. Mr. Redfield, if you sign off on the JNS, Mr. Villar's case. I think Mr. Aberco is signing it as we speak. Well, good luck to you. Get a copy of the paperwork by going to the window outside the courtroom to your left. I'm going to wish you the best of luck. You take care of yourself and have a good day.
Thank you.
See Sarah Hayes. Just give me a moment. Okay. One sign. So, Your Honor, the matter comes before the court for a pretrial hearing on a theft charge to which she intends on entering a straight plea of guilty. I've prepared a statement of defense on the plea of guilty, with which I've reviewed with her and asked the court to inquire.
Good morning, ma'am. For the record, is your name Sarah Lucille Hayes?
Yes, Your Honor.
Ms. Hayes, I'm looking at a statement of defendant on plea of guilty to one count of theft in the 3rd degree. Plea form tells me you're 42 years of age. Any problem at all reading and understanding the plea process?
No.
With your attorney? The third is a gross misdemeanor. The maximum penalty and conviction to be 364 days in custody and or a $5,000 fine, which I'd be free to impose regardless of what's recommended if I accept the plea. You realize that?
Yes.
And if I accept the plea, you give up the rights contained in paragraph 5. There's no trial, no appeal, simply the sentencing. With that in mind, with regard to one count of theft in the 3rd degree alleged to have been committed within the city of Yelm on January 15th, 2023, how do you plead guilty or not guilty?
Guilty. Guilty.
You make that plea of your own free will.
Yes.
Anybody make any threats or promises to you, make you plead. I'll find the plea to be freely, knowingly, and voluntarily made. And your statement in paragraph 11 does satisfy the factual elements.
Yes, sir.
Now, I've heard the recommendation, but you have a right to tell me anything you wish that you think I should know. You don't have to say anything if you don't want.
Thank you. I'll pass.
Mr. Haverko, anything to add to the recommendation?
Nothing to add, Your Honor. Ask the court to follow the recommendation.
Says I am going to follow the recommendation, 364 days in jail, suspended on the condition of law-abiding behavior and the payment of a $250 probation fee, which you can make the payments of $25 a month towards that. If there's a problem making the fine payments, let us know. The most important thing here is law-abiding behavior. You know, the law is basically 2 things. Don't mess with other people's stuff and don't do any harm to other people, period. That's about it. So I'm hoping you'll learn from this. Any questions at all?
No, I can do that. Thank you.
I am signing the paperwork in connection with this. You can get a copy of the today's paperwork by going to the window. I want you to get a copy of the paperwork, review it carefully, and give Mr. Haverko a call if you have any questions, okay?
Thank you.
Good luck to you.
Thank you, Your Honor.
You can call me Dorino Graves. That is number 2 on the 10 o'clock calendar. I think the city has a motion.
Our city,
Mr. Graves, the city has moved to dismiss the charge against you. I assume you have no objection to that?
no, sir.
Based on that, charge is dismissed. You're free to leave at this time. That concludes the matter.
Thank you, Judge.
Mr. Graves, good luck to you. You take care of yourself.
I think I still need to meet with Mr. Strobel and dental staff. Maybe we could address Mr. Reed Hauser right now.
What is your name? Gareth Charles Reedhausen.
Correct. So, I'd have to look at my notes, but it was this week, I made a phone call to Mr. Reedhauser, and I made a series of about 4 or 5 telephone calls. And the first telephone call I got hung up on. The next phone call was, who's this? I tried to identify myself, got hung up on. And then there were kind of people in the background kind of laughing. And so I kept trying to tell Mr. Hauser that, hey, I was appointed to represent you. I'm trying to talk about your case. And then he,
That wasn't me to answer the phone.
Who?
That's not my phone number, my uncle's phone number.
who was I talking to?
That's probably my uncle's friend that was in the background. You know, in the truck right now.
So apparently I was not talking with you? Okay. So whoever I was talking to said they were him, and then they thought it was a prank call, so I haven't had a chance to talk with him.
You know, if it was me, I'll hang out.
Do you have the telephone number? Have you confirmed that you're calling the right number?
Do you have a number where I can reach you?
Yeah.
What's the number?
253.
Okay.
387
387?
6114.
Depending on how busy we are, perhaps there might be time to just chat with him this morning. So Mr. Reedhauser, why don't you go ahead and have a seat for now? Seat yourself.
Read out there if that's the situation that somebody was pretending they were you. That's they could have wound you up with a warrant for your arrest, or hey, we need to hold you, or something. Yeah, that they didn't do you any favors. So, but if you'd have a seat and yeah, I'm gonna defer to your attorney if he wants the matter reset. We can do that.
Yeah, I just have Mr. Reedhauser sit for a bit because we may have time to get to him. It's
Okay.
not super busy today, and so, I'm thinking.
Great.
Let's see. I need to meet with Mr. Middlestat and
Perhaps it's
and
time for
Mr. Strobel, he's here and I need to meet with him. And so then I may have time to.
We're gonna take a short recess
Yeah.
and once. Thank you for your patience, all of you. You never know how long a case is gonna take. And so your case will get the attention it deserves. Bear that in mind. Thank you for your patience. Thank you.
11 o'clock.
Wait, sir, just a matter of, Yelm versus, Garrett, Charles, Reed, Hauser. Is that your correct take?
So I misspoke. It's on the 10 o'clock, item number 6, 7, and 8. Parties have reached an agreement. Reviewed their police reports with them and talked about all cases, and we're proposing to enter a straight plea on the case ending in 028 theft. On the case ending in 493, that's the obstructing. Upon the court's acceptance of the plea, city will move to dismiss the case ending in 034.
Mr. Riedhauser, do you disagree with anything you just heard? No. I am looking at a statement of defendant on plea of guilty to one count of theft in the 3rd degree. That's the November 6th, 2019 charge. And a plea of guilty to a obstructing charge, December 9, 2022. Both of those are what they call gross misdemeanors. The maximum penalty and conviction would be 364 days in jail and or a $5,000 fine, which I agree to impose regardless of what's recommended. You realize that. If I accept the plea, you give up the rights contained in paragraph 5. No trial, no appeal, simply a sentencing from which there would be no really. You realize it. With that in mind, as to one count of theft in the 3rd degree alleged to have occurred within the city of Yelm on November 6, 2019, and one count of obstructing a law enforcement officer in the performance of his duty, again alleged to have been committed within the city of Yelm on December 9, 2022. How do you plead, guilty or not guilty to those charges? You make those pleas of your own free will. Yeah. Anybody make any threats or promises to you to make you plead guilty? I will find the pleas to be freely, knowingly, and voluntarily made. And your statement in paragraph 11 does satisfy the factual elements. Mr. Evergo, anything to add with regard to the recommended sentence?
Nothing to add, Your Honor. Just ask court to follow it. He'd like to make payments on the proposed fine.
Mr. Evergo, anything to add? Mr. Riedhauser, anything you'd like to tell me? Anything you think I should know? You don't have to say anything. You're shaking your head, the negative. I will follow the recommendation, 364 days suspended on each charge, $250 probation on each charge for a total probation fee of $500. That you can pay at the rate of $25 a month or more if you can. The jail time is suspended on really just one condition. Stay out of trouble. No criminal law violations. We have three charges here, 2019, 2020, and 2022. That might lead one to believe that you're not learning from past mistakes. We learn from our mistakes and we're condemned to repeat them, and that's always been true and will always be true. All I can do is wish you the best of luck, remind you that you do have these charges or the suspended time hanging over your head that could be imposed if there's a violation. Good luck to you. Get a copy of today's paperwork by going to the window outside the courtroom to your left. Review it carefully, and if there's a question, give Mr. Haverco a call, okay? All right, thank you. Jericho.
Thank you, Judge. Next matter is on the 10 o'clock calendar, item number 9, Eric Strobel.
Good morning, sir. Good morning. Full name Eric Strobel. Mr. Strobel, turn to your attorney for the Status of the matter?
Thank you, Your Honor. It's a DUI case and he and I haven't had much of a chance yet to speak. We did this morning. And also he hasn't had an alcohol drug evaluation. So we're asking for a continuance. We've submitted a motion in order to continue, and the basis is to seek out and obtain a chemical dependency evaluation and see where he's at before he makes a decision.
It's how far out would you like to go?
I think I'd like to go at least 6 weeks. Just because, takes a bit, you gotta contact an
March
agency
30th,
and,
maybe?
yeah,
March 30th, April 13th.
Yeah.
Whichever works best.
April 13th.
April 13th it is.
Yeah.
Strobel, we're resetting your matter to April 13th at the request of yourself and your attorney. We'll see you back here. Then stay in touch with your attorney. And again, law-abiding behavior is a condition of release in any criminal charge.
All right.
Any questions at all?
No, they.
I'm electronically signing an order resetting the matter. Mr. Strobel, if you'd get a copy of that at the window outside the courtroom to your left, we'll see you back here in April. Good luck and take care.
Thank you.
Next matter would be on the 11 o'clock, Gary Riley, it's number 8.
Good morning, sir.
Hello, sir.
The matter comes on for a pretrial hearing on hit and run unattended, and we're proposing the court accept the stipulated order of continuance, terms of which are in the agreement, and ask the court to inquire.
For the record, your name is Gary Dean Riley. Mr. Riley, I'm looking at on the computer screen here what they call an SOC, a stipulated order of continuance. It's basically a contract between yourself and the city negotiated by your attorney, and the terms of which, according to the instrument, over the next 12 years, if you stay out of trouble, pay a probation fee in the amount of $250. There may be a restitution issue that is reserved for a future court hearing if it comes up. If you do that at the end of 12 months, the charge will be dismissed. Now, if you violate the agreement, in return for getting the agreement, you've given up your right to go to trial. The agreement's violated, we'll have a hearing that'll be based solely upon the police report, whatever else the city wishes to present. And you know what the result of that would be, the possibility of up to 90 days in jail and a pretty good fine.
Yes, sir.
Mr. Riley, I'm going to wish you the best of luck. You've got a chance here to get this charge dismissed. And whether you take advantage of that opportunity or not is up to one person. That's you. Thank you.
He'll sign everything and then tell you to head up to the window and pick up copies. Yeah. Oh, you won't. Yeah.
Mr. Riley, you can get a copy, and please do, with at the window outside the courtroom. Read it over carefully, and if you have any questions at all, give Mr. Africo a call, okay?
Thank you, Your Honor.
Good luck to you.
Thanks.
Let it come on. We're kind of, yeah, come on.
Good morning.
Kind of skipping around here.
And this is,
It's okay. This is Mr. Middlestad. He's number 4 on the 10 o'clock calendar. And we are submitting a motion for a continuance. He has another matter in another court, the resolution of which is going to occur, I think, sometime March 27th. And so we would ask for a, pretrial date after that time.
April. Is it April 13th or 27th?
13th, okay?
Sure. Mr. Middlestad, at the request of yourself and your attorney, we're going to reset the matter of the April 13th.
Thank you.
I'll sign an order to that effect here in a moment. Get a copy of the order at the window outside the courtroom to the left. Stay in touch with your attorney and of course, law-abiding behavior in the meantime. Any questions at all?
Not at all, sir.
Good luck to you. See you back here in April.
Thank you very much.
Yes, sir. So this is Ms. Treadwell. What's that?
Good afternoon, ma'am.
Good afternoon, Your Honor.
So she comes on for two pretrials for thefts. They're quite some time ago. No priors to that and no prior subsequent to that. So I think things have kind of turned around. So asking the court to accept an SOC stipulated order of continuance on both matters.
Ms. Treadwell, good morning. For the record, your name is Mandolin Rose Treadwell.
Yes, sir.
That's it. I'm looking at the SOC stipulated order of continuance, and again, I'm going to repeat myself. It's a contract under the terms of which, if you do what you're obligated to do, charge will be dismissed. If you violate the agreement and the city proves that by a preponderance of the evidence, we'll have a hearing based on the police reports, and that would subject you to up to 2 jail terms of 364 days each. The agreement here is you're going to pay a probation fee in the amount of $250, which you can pay at the rate of $25 a month. And most importantly, no criminal law violations. Stay out of trouble. It looks like these both go back to 2016. They've got a little age on them, but hopefully you remember it well enough to have learned from the experience, and it's one to not be repeated. Any question at all?
No, I just want to say that in 2016, that was a very, very dark time in my life. And I have grown up. I've gotten a lot of help and I am doing a lot better. And I sincerely appreciate this chance. And I will waste it.
That's good to hear. That's great to hear. Life is not without its dark times and its speed bumps. There's potholes on the lane of memory, but I'm glad to hear you're doing much better and life is doing well. Hey, thank you for appearing. Been a while since 2016, but that's behind you now. I look forward to 1 year from now dismissing the charges and closing the case. With regard to the court costs or the probation fee, that's the least important thing to me. If there's a problem making the payments, let us know. We can deal with that. There's community service. There's other ways.
Is that $250 just flat, or is that $250 per charge?
It looks like it's just $250, period. That'll be a divide by 2. It looks like $125 in that charge. So 25 a month, first payment March 2nd. And again, don't let this be a problem. Let us know if it is.
Okay, thank you.
Good luck to you, and you take care of yourself, and good to see you.
It was awesome.
Take care.
You're not here for court.
No.
Okay. So it looks like Aaron Hansen just came in. I haven't had a chance to chat with him, so I'll
Want to go on record?
Yeah.
The record call the matter of Yelm versus Aaron Hansen.
Yes,
Mr. Hansen, good morning.
Good morning, sir.
Is your name Aaron Otto Hansen?
Yes, it is.
So matter comes before the court for a pretrial hearing. I've had a chance to review the case with Mr. Hanson. He intends on entering a straight plea of guilty to count 2, the ignition interlock violation, and upon the court's acceptance of the plea, city will move to dismiss count 1, suspended driving 3rd degree.
Mr. Hanson, do you disagree with anything your attorney just said? I'm looking at a statement of defendant on plea of guilty to 1 count of operating a motor vehicle without ignition interlock. And that involves a dismissal of a driving license suspended charge. Plea form tells me your full name is Aaron Otto Hansen and you're 51 years of age.
Almost 50.
Any congratulations. Any problem at all reading, understanding the plea form? I'll take the head shake as a no. If I accept the plea, you give up the rights contained in paragraph 5. There's no trial, no appeal, simply a sentencing, which, this being a gross misdemeanor, could be up to 364 days in jail and up to a $5,000 fine. You realize that?
Yes.
With that in mind, as to 1 count of driving without ignition interlock, within the city of Yelm on December 10th, 2022, when your right to drive without ignition interlock was suspended by the Department of Licensing. With regard to that charge, how do you plead, guilty or not guilty?
Guilty with that.
Do you make,
Yeah, guilty.
do you make that plea of your own free will?
Yes.
Anybody make any threats or promises for you to make it? I will find the plea to be freely, knowingly, and voluntarily made, and your statement in paragraph 11 does satisfy the factual elements of the charge. Now, the recommended sentence is for suspended jail time and a probation fee. You have a right to tell me anything you wish regarding the matter, anything you think I should know. You don't have to say anything, but if you have anything to say, now's the time.
No,
Go ahead.
I got up a picture a while back here and already just getting back on my feet here. Didn't go well, and I get that and my license back and my head here with that science.
Back on your feet. I like to hear that.
And then,
Like,
huh?
So,
Yeah.
Mr. Hanson, following the recommendation, 364 all suspended, 250 probation fee. If there's a problem making the payments on the probation fee, let us know, we can deal with that. The most important thing is no law violations. That would include, you've got to have ignition interlock if you're driving, and the Department of Licensing has that as a requirement. Okay? Any question at all?
No.
Reviewing the matter electronically. Mr. Hanson, I've got electronically signed today's paperwork. I want you to get a copy of it by going to the window outside the courtroom to your left. Review it carefully, and if you have any question at all, give Mr. Haverco a call, okay? Any question at all?
Yeah.
I'm going to wish you the best of luck. You take care of yourself.
Oh, yeah, get that, do a couple more things. Don't blow the light here. I'm working on it.
Hey, don't give up. That's the important thing. You're back on your feet.
Almost, I can good deal that earache and the sinus problem, throat problem, and the CAT scan and test, I don't know.
I'm going to wish you the best of
I'm gonna
luck.
go there, fix me or what, but I'm working on that too, so.
Good luck with that. You take care of yourself
I will. Thank you.
as best as you can. And I assume we don't have anybody in the appearing. Yes. Before we go off record, let's address the no-shows. The first one I have is page 8. Number 10, a compliance issue with Miranda Louise Williams.
Yeah, I haven't had contact with her and no contact.
City wish warrant.
Yes,
Next would be Michelle Zenner.
You know, it kind of off and on, you know, I haven't had any recent contact, but sometimes she'll send me an email. You know, having to do with kind of civil rights articles and different things. So I don't know if she goes to a library or what, but I don't have any information as to why she's not here.
If you're in some sort of minimal contact with her, prefer to just reset it.
Yeah, we can just reset.
Let's reset it with notice, unless the city has any. Note that on appearance for speedy trial purposes, reset with notice.
And then on Bingaman,
Mr. Bingaman,
okay.
you're just here before the issuance of a warrant. Come on in, sit down.
So I need to, since we have a little bit of time, the clerk could give me a little bit, I can chat with Mr. Bingaman.
Back on the record, call a matter of Yelm versus Kevin Bingaman. And for the record, sir, your name is Kevin Porter Bingaman? Yes, sir. If I mispronounce your name by any chance, I apologize.
Go ahead and send me. Plugged in now. Why is that not working? I'm plugged in. Let's try it again. Okay, try it again. This time it's plugged in and God damn. Oh, jeez. Looks like it. Good. Let me save it. Then pull it up again and see if I can. Okay, so I think this program's a little fussy. Okay, try it again. Huh. Let me plug it in again. Take it. Okay, it's plugged. There we go. Okay. Okay. So this is Mr. Bingham, comes before the court on 3 cases, each of which is before the court for a pretrial hearing. He is going to enter on case number ending in 798. He's going to enter a plea to count 1 that's amended to criminal trespass in the 2nd degree. Upon the court's acceptance of that plea, city will move to dismiss count 2, the paraphernalia count. He's also going to enter a straight plea on the case ending in 294, another count of criminal trespass 2nd degree. And then again, as part of an agreement, then upon the court's acceptance of all the pleas, then the city will move to dismiss also case number, the 3A case for the no valid operator's license. It's part of just a, yeah.
Mr. Bingaman, do you disagree with anything at all Mr. Haverco just said?
No, sir.
I'm looking at a statement of defendant on plea of guilty that tells me you're 33 years of age and your full name is Kevin Porter Bingaman. Have you gone over the plea form with Mr. Haverco? And have you had any question at all? Was your question answered? The plea of guilty, the pleas of guilty are to basically 2 counts of criminal trespass in the 2nd degree. The first one amended down from 1st degree occurring on September 23rd. The second one occurring on December 11th, both of 2022. In return for the pleas, if they're accepted, there's a dismissal of the paraphernalia charge and the no valid operator's license charge as well. Is that your understanding?
Yes.
If I accept the pleas, you have the rights contained in paragraph 5. There's no trial, no appeal, simply a sentencing, which could be up to the maximum, which would be 90 days in jail and $1,000 by way of fine. With regard to each charge, you realize that. With that in mind, as to 1 count of criminal trespass 2nd degree alleged to have occurred within the city of Yelm on September 23, 2022, and a 2nd count of criminal trespass 2nd degree alleged to have occurred within the city of Yelm on December 11, 2022. How do you plead guilty or not guilty? Do you make those pleas of your own free will? Anybody make any threats or promises to you to make you plead guilty? No. I will find the pleas to be freely, knowingly, and voluntarily made, and your statement in paragraph 11 does satisfy the factual elements of the pleas. Recommended sentence is suspended jail time and a basically a total $250 probation fee, $125 each case. That's a recommendation. Is there anything you'd like to tell me or think I should know? No, sir. Mr. Haverco, anything to add?
Nothing to add, Your Honor. It's asked the court to follow the recommendation.
Mr. Bingaman, if you have anything to say, again, now's the time. That's it. Because I know I'm going to follow.
both counts, I didn't even enter the store or anything, it was just in the parking lot, and the first time it was, I thought it was a year, and a year has well been passed since the last time, and the second time, I was literally in the parking lot, just moving my stuff, because I got that moving and everything, so, I mean, I know now not to go to the Walmart property all around, so.
You'd think, you know, that's, hey,
Yeah.
it just mean going in the store, but no, the trespass order actually is for the entire premise.
Yeah.
Parking lot, any abutting structures, et cetera, et cetera, et cetera.
Yeah.
Follow the recommendation, all jail time suspended on the condition you have law-abiding behavior. Nobody wants or should go to some place they've been trespassed from. And a total $250 by way of probation fee, which you can pay at $25 a month. Any question at all?
No, you said I can do a payment plan on that? and
You certainly
I-
can.
I get
25 a month.
stability, that's all, so.
25 a month. Now, that's the least important thing to me. The important thing is stay out of trouble.
Oh, yeah, of course.
Stay out of trouble, of course. If there's a problem making the fine payments, 25 a month, let us know. We can figure out another way of dealing with it.
Okay.
All this, you know, community service, other things.
Okay.
But good luck to you. You take care of yourself.
Thank you.
And it's gonna take me a moment to electronically sign off on everything, but I want you to get a copy of it at the window outside the courtroom and to the left. And review it carefully, and if you have any questions, get a hold of Mr. Hammond.
Okay, I will.
Good luck.
Thank you.
Oh, 1 o'clock? Oh. Oh, from where? Oh.
And I think for the no-shows, we left off at Mr. Bingham, who walked in just at the very last moment.
Right.
The next one that I have is a no-show, and there is something in the queue for that is docket number 7, page 10.
Yeah.
SNSEO.
Yeah, so I'm surprised that they're not here. I did have a conversation with them and you know, had a proposed resolution, so I assume they were gonna be here. I haven't had any contact since that contact, or I haven't received any notification about if and why they weren't going to be at court, so I don't have any other information.
It sounds like you've been in contact. I'm assuming there's probably some sort of mix-up. I have no problem. Note the non-appearance for speedy trial purposes and reset with notice.
Okay.
Let's reset with notice. Of course, if I didn't say it, noting the non-appearance for speedy trial purposes. And I think that leaves just Philip Germino, page 11.
I had a phone number and, you know, called the number and it was one of these, the response was, a system message that said either the phone is either not available or, message box hasn't been set up. So anyway, it sounded like it could be a cell phone. So I did text the number saying, hey, I'm your Yelm public defender attorney, please call me, and haven't received any contact, so.
Well, I think the city have a motion in the case.
Your Honor, yes.
2,500 cash or bond, I think. Note the non-appearance and oral issue, failure to appear.
And but seated, just so for your or for your honor's information, seated behind me is Clifford Jones. He's quite early, but he's scheduled for an arraignment on the 1 o'clock calendar. I guess my thought was, since he's here, we're here, perhaps we could just do his arraignment.
Why don't we do that?
Yes, why don't you come on?
Mr. Jones, come on up and have a seat.
How are you, my honor?
You told me you would appear. It's good to see you. I'm glad you did. For the record, your name is Clifford, middle initial D. Jones.
Yes, Your Honor.
Mr. Jones, the citation I'm looking at alleges that on or about January 19th, 2023, you committed the offense of theft in the 3rd degree. That charge is a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and a $5,000 fine. As you know, you have a right to have a lawyer represent you, and I'm going to, under the circumstances, appoint Mr. Averco to enter a plea on your behalf, and he'll represent you with regard to, he's already your attorney for the other cases. He'll represent you with regard to this charge as well. Mr. Averco?
Thank you, Your Honor. Would stipulate to probable cause, ask the court to enter not guilty plea.
Mr. Jones, a plea of not guilty has been entered on your behalf. Your other cases are set for February 16th at 11 o'clock. We're going to do the same with this. We're going to consolidate all the cases. Now stay in touch with your attorney and, you know, very importantly, show up for court.
Yes.
I'm glad to see you here today. You're very early, actually.
So I just wanted to make sure I made it because I'm tired of missing court here so much, you know, and I would apologize for as many times as I have, and I'm trying to make some changes.
You're here. That's the important thing. So, and please, conditions release, law-abiding behavior, stay out of trouble.
Yes, Your Honor. And if I could get contact information for you, Mr. Habaco.
Do you have a phone number?
I don't currently have a phone number that, but I would like it to be, I'm gonna get one, but I would like yours so I can maybe get a hold of you to talk to you about.
Yeah, they'll give you an appointment sheet and it'll have my number on it. Just make sure once you get a phone number, a way to call me, just make sure to call.
Cause I need some legal advice, like big time. I'm trying to make a few changes in my life here and, I think you could help me out a lot and, I just need to run some things by you.
Yeah, give me a call.
Jones, thank you for appearing once again. You take care of yourself and we'll see you back here later this month, February 16th.
Yes, sir. Thank you.
So with that, I think we can go off record. Back on record, going back to the morning, early morning calendars, Trey Jones, who was being held in jail, was either supposed to be here or was going to be addressed from jail. He did not appear, and he apparently had been released from jail. City wish for a warrant.
Yes, city warrant is,
We did get a phone call saying that from a parent. I think he's at page 3, number 5. I think given the charge, I'm inclined to forfeit the bond
thank you.
if it's still in.
And just mark that as being that, so.
We were gonna deal with him from the jail, but it turns out that he had been released apparently by the time, and he had been scheduled to appear at 8:15 calendar, so 2,500 cash or bond, and if the warrant or the bond is still in effect, forfeit the bond. The other matter is Antonio Clark. I think the city had motions.
City moves to dismiss the,
Any and all warrants issued in connection with Antonio Clark are quashed, and all charges pending against Mr. Clark are hereby, and the same are dismissed. With or without prejudice? With prejudice, I'm assuming. With prejudice, it is. And with that, we'll be off record until 1 o'clock. See, when we get started, we're gonna take your matter first, I understand. Thank you. Thank you, I appreciate it. Let's go on. Good morning, we're gonna call the 1 o'clock arraignment calendar. This is your first appearance after receiving a criminal citation. I'll call you up one at a time. Before I do that, I need to advise you, you have a right to have a lawyer represent you at all stages of a criminal proceeding. Mr. Haverco, seated at the council table, is our public defender. He will at least enter a plea on your behalf at this hearing and represent you throughout the course of your case, should you be indigent and should you so request. That's a conversation that should be held out of my sight. At the arraignment, a plea of not guilty is invariably entered. That preserves your rights until you can have a pretrial, give you a chance to review the case, discuss it with your attorney, and your attorney in turn with the prosecutor. If it's possible to resolve the case by agreement, that is something that's put on the record. If you can't resolve the case by agreement, you do have a right to a public and speedy jury trial in the county where the offense was allegedly committed. The first matter I'm going to call is Yelm versus Marvin George Green. Mr. Green, is that your full name? Yes, sir. Citation alleges that on or about January 16, 2023, you committed the offense of driving while license suspended or revoked in the 3rd degree. Now that is a simple misdemeanor, but the city may have a motion in your case.
Yes, Your Honor, city moves to amend charge to the second.
What that means is this. Driving a license suspended or revoked 3rd degree is a misdemeanor. It's a crime. You could face the possibility of 90 days in jail if you were convicted of that crime. The city has amended the charge to a civil infraction. With a civil infraction, the most that can be done is the imposition of a fine. If you admit that you didn't have a driver's license that was valid on your person when you were cited on January 16th, I'll assess a $150 fine, and that'll close the matter. Is there, do you admit or do not?
I admit.
Impose a $150 fine. The question I have is, do you know what you need to do to get your license reinstated?
Well, actually, I have to quote with you again, in Savannah. When I come to Savannah, I'll have my license paid off. It's $500.
It's pretty easy to lose, a lot harder to get it back. Get your license reinstated, and once you do that, make sure you keep it in effect. Okay. I'm signing an order reducing the charge and amending the charge, I should say, and setting the payments at $25 a month. First payment due March 2nd. Mr. Green, you get a copy of today's order by going to the window outside the courtroom to your left. Thank you for appearing. Thank you for your patience, and good luck reinstating. You too. Take care. Go back to the top of the calendar. It might be a little easier to ask who is here, but we'll go through the calendar. Juan Acosta, Latasha Beckman. Ms. Beckman, come on up and have a seat. Full name, Latasha Dawn Beckman.
What was that? I'm sorry.
Citation I have alleges in honor about January 22nd of this year, 2023. You committed the offense of driving or assault 4th degree domestic violence. That charge is what they call a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. I'll have Mr. Aberco enter a plea on your behalf.
Stipulate to probable cause, score 10 or not guilty plea.
Ms. Beckman, a plea of not guilty has been entered on your behalf. Again, that preserves your rights pending a pretrial. Condition of release, when I spoke to you on the 23rd of January, was no hostile contact with Casey Beckman. That remains in effect until modified. Your next hearing will be March 2nd at 11 o'clock in the morning. I will be signing an order setting the hearing, and you can get a copy of today's order at the window outside the courtroom and to your left. Now, the order will have the contact information, address, and phone number of your public defender, and he'll want to get your contact information. If you give him a telephone number or at this time, that'd be great.
Yeah, just one second here. Do you have an opponent?
732. 80.
Yeah.
Ms. Beckman, I've signed today's order. Again, get a copy of it at the window, review it carefully and stay in touch with your attorney. Any questions?
No.
Good luck to you. Take care. Chara Caldwell, Scott Custer, Steve Dungan, Brandy Ehrlich Ford. Good afternoon, ma'am. If you'd step forward and have a seat. Now, this is going to sound familiar. The citation I have is the same one as we dealt with earlier for Mr. Green. You were cited for driving a license suspended or revoked in the 3rd degree, and the city may have a motion.
Yes, Your Honor, city moves to amend the charge to no bond in the 2nd degree.
And what that does is change the case from a criminal prosecution to a civil infraction. If you admit the infraction, Ms. Ehrlich Ford, I'll impose a $150 fine. If you deny it, you're entitled to a contested hearing on that. You admit or deny? I'll set your fine at $150, payment $25 a month, first payment March 2nd. And again, I want to encourage you to do whatever you can to reinstate your license. Wonderful. Easy to lose it, like I said, harder to get it back. Once you get it back, make sure you keep it, okay? Good luck to you. Again, get a copy of today's order at the window and thank you for appearing.
Thank you.
Sarah Flynn. Stephanie Holanowski. Joseph Kokorek is going to be late. I understand. Hannah Morgan. Carissa Perrick. Leroy Reyes. Mr. Reyes, come on up and have a seat if you would. Mr. Reyes, the city may have a motion in your case as well. You were cited on January 24th for DDoS 3rd, which is a criminal offense. You're also cited for no insurance. That's already an infraction. City may have a motion with regard to your.
Yes, Your Honor, city moves to amend the charge in 2943 to no bond in the 2nd degree.
Mr. Reyes, that means you now have 2 civil infractions, no more criminal offenses. If you admit the infractions, I'll assess $150 on the driving while no valid operator's license. And the no insurance on its face, that was a $553 ticket, but I'll be reducing that. If you admit the infractions, I'll reduce it. Are you admitting or denying?
Yes.
Wait.
Well, my insurance didn't cover the vehicle.
Pardon, what happened?
I just got that truck running and I was driving it to see it. I didn't have it covered.
Oh, boy. Well, why don't we do this? $150 on the no valid operator's license and $100 on the insurance. I'd rather have you spend money on getting insurance than.
Yeah. Well, I did. It just wasn't on that vehicle.
Yeah.
It wasn't covered. Is what it was. I wasn't expecting to get pulled over.
We never are. We never are.
Right.
But Mr. Reyes, I'm signing an order reducing and assessing total of $250, $25 a month, first payment March 2nd. Any questions at all?
No, not.
And again, I'm going to encourage you to do whatever you need to do to reinstate your license.
Well, I've already contacted licensing, from what my understanding, it's supposed to be good, and I don't know what happened, I'm waiting to get them to reply, even how licensing is.
I'm
They
going to
do
wish
it
you
in
the
their own
best.
time.
I'm going to wish you the best of luck with that. Is there any way we?
Is that it?
We're trying to figure out if we can tell why.
Cause I just renewed my license and it, a little over a year ago. And they,
Usually it's for an unpaid ticket, but it could be, child support, this,
I
that.
don't have the kids.
Well, it's not that.
There's three issues that I also said, collision claim.
Maybe a financial responsibility thing. It might have been in an accident or something. So we can't tell from
Right.
what we have, what the problem is, but don't give up on it.
Gotta wait for license.
Keep working on them until they respond.
Okay.
Mr. Reyes, thank you for appearing. Good luck to you. Take care.
Thank you.
Thomas Royal, Kylie Shelton, Timothy Willoughby. Mr. Willoughby, finally. Afternoon. For the record, Timothy Eugene Willoughby.
Yes, sir.
Citation alleges on or about January 20th of 2023, he committed the offense of driving while under the influence of intoxicants. That's a gross misdemeanor. The maximum penalty on conviction would be 364 days in jail and or a $5,000 fine. I'll turn to the public defender to enter a plea on your behalf.
Stipulates probable cause as the court to enter not guilty plea.
Mr. Willoughby, a plea of not guilty has been entered on your behalf. The city, I'm reviewing the record here. Does the city have any request for any special conditions? Mr. Willoughby, you do have, you were cited for DUI 1, 2, 3 times prior to this with varying resolutions.
I've never had a DUI in my life, and the other ones were dismissed with prejudice.
That was, I did say cited.
Okay, yeah.
There is a guilty on one of them of record, and that would be 1995. Now, they're all outside of 10 years. That is something you can discuss with some judges would order you to do ignition interlock, but the conditions of release are going to definitely be no drinking, no driving unless you're licensed and insured, no drinking and driving. If any officer for any reason asks you to take a breathalyzer, you to do so. Any question at all?
No, sir, I do have a question,
But that is something to talk to.
I'm not sure if I should talk to you or anybody.
And again, today's order will have Mr. Averco's contact information on it, and he'll want contact information from you as well.
606.
Sign here.
What's this I'm signing?
That's the court order with the requirement to appear.
Well, it's not showing nothing.
Yeah, just sign it.
Just sign it. Okay. Did it show up? Okay.
Yeah.
You can't see it on the back, reach it.
Yeah, that's how they did it. They'll give you an information sheet. Yeah. Yeah, we'll need to talk about your case.
Will be the next hearing will be March 2nd, 11 o'clock in the morning. Again, I'm signing an order setting the hearing, and you can get a copy of that at the window outside the courtroom and to your left. So, any questions at all?
Yes, sir. Thank you.
Good luck to you. See you here in March.
All right, thanks.
Yeah, just leave a message.
Okay, go. And that would appear to be, unless we have somebody on, I will, I think a lot of the no-shows I released on their promise to appear will go off record until I've got a chance to review that. Let's go off. Gonna go back on record with regard to the 1 o'clock no shows. Off record, I have reviewed each and every case. Every single case for which a warrant has been issued. I have previously found probable cause because I released each and every one of these individuals from custody. Found probable cause before I did that. And it was they were released on their firm assurance that they would appear for court. Sir, are you here for court? And your name is?
Joseph, sir.
You're
A little late, I'm sorry, I was calling the whole time here. I missed the bus and every hour.
you did?
Yeah.
And now the public defender is not here, Joseph. So no warrant is going to issue for your arrest, but we're going to have to give you another court date. If that's, I'm sorry to have to do that, but.
I understand how the bus works now, and I'll really.
Because yeah, with the bus, you've got to kind of.
I'm not ready.
Hey, no problem, no problem. That happens. That happens. There's not going to be a warrant. You're just going to get another court date and have to make the long trek back. What now?
That's all the other people.
You did tell me you would be here and no, I pulled your file out when I was going through, I have to find probable cause before I issue a warrant. And I remembered you'd been calling here. There wasn't going to be any warrant anyway because you were in touch. Yeah, as long as you're in touch, everything's okay. But I don't want to address your case without the public defender being here and he's going to represent you in the matter. So.
Do you have his name?
We do. His name is Dan Haverco, but there's no point in talking to him now. He wouldn't want to talk to you until he's looked at the police reports. There we go. Yep, and nothing for you to sign. What, if you go to the window out in front, Joseph, and ask for a copy of today's order, tell them who you are, and they'll give you a copy of it. You're being reset to February 16th at same time, 1 o'clock. But we'll see you then. You take care. Sorry about the wasted trip down here, but at least there isn't any warrant for your arrest. Take care.
Thank you.
Pardon? Okay. Okay, going back to the top of the calendar, Juan Acosta, probable cause previously found, 2,500 cash or bond. Charles Caldwell, released from custody, BC, probable cause previously found, 2,500 cash or bond. Scott Custer did request another reset, and I think as long as he's in touch, just go ahead and reset with notice. The next is Stephen Dungeon. Interesting case history, has over 20 felonies. I stopped counting when I got up to 20. He's born in 1969. He's no child, but amend his charge from DDoS to no ball 2 and do the usual FTA. So. The next one is Sarah Quinn. Probable cause previously found, and she's previously failed to appear on each case, 2,500 each. Next would be Stephanie Kolonowski. I think just nothing, let's not do anything with docket numbers 10, 11, and 12. The following page 13 and 14. Probable cause for theft, third, and contrast 1. I found both when I talked to her, and against my better judgment, did release her on her promise to appear. She so fervently sure that she would appear. The 2,500 each. 13, 14. Now the previous ones, we're not going to take any action on that. Oh, 12 is arraignment too. Okay, I missed that. $2,500 on that as well. For some reason, I thought that was sentence compliance, but that was the other two of the 5 cases she has on the docket. Next would be Joseph did show up. Probable cause was found because he was released from jail. That's next is Tana Morgan. I previously found probable cause for Crim Trust 2 when she was released from jail. $2,500 cash bond. Carissa Perry, I talked to her just I think it's day before yesterday. Yeah, the first. And she promised me she would be here day after tomorrow. That being today, she did not. $2,500 cash bond. And then next would be Travis Royal, amend to NDOL with ID and then FTA that. And last would be Kylie Shelton. I did find probable cause when she was released from custody on her promise to appear. $2,500 cash bond. The 1 o'clock. Call the matter of Yelm versus Samuel Newman. Mr. Newman, are you here? Come on up and have a seat. We'll take your matter now. You were originally cited with driving license suspended, revoked third degree. A criminal offense. The city amended it to a civil infraction, no valid operator's license with ID. And you've asked for a contested hearing, and that's what we'll have. You're entitled to that. What I do is read the officer's report, listen to what you have in defense of that, and then I'll rule one way or the other. The burden of proof on the city is by preponderance of the evidence, not beyond a reasonable doubt, like it would be in a criminal case. But here's what the officer writes. On January 8th, 2023, at approximately 0913 hours, I conducted a traffic stop on a blue Hyundai Elantra bearing Washington plate BYK 6149 at the intersection of Berry Valley Road and Southeast Berry Valley Drive, southeast. Prior to my stop, I observed the blue Elantra traveling east on the Yelm Avenue West. Multiple times, the blue Elantra applied its brakes due to traffic in front of it. And each application of the brakes, I noticed the rear center high brake light was not functioning. As I continued to follow behind the blue Elantra, it made a quick and abrupt right turn onto the Berry Valley Road southeast without using a turn signal. I activated my overhead lights and conducted my traffic stop at the intersection of Berry Valley and Berry Valley Road Drive southeast. I made contact with the driver identified by his Washington State driver's license as Samuel Newman, advised him of my reasons for stopping him: non-functioning center high brake light and no turn signal. Samuel asked to check and see what I was talking about, to which I advised him to wait until the traffic stop was completed. I also advised Samuel to remain in the car. As I returned to my car, Samuel quickly opened his driver's side door to get out. I redirected my attention directly to Samuel and advised him to remain in the vehicle. Samuel had to be told multiple times to return to the inside of the vehicle. Samuel said he wanted to verify what I told him to make sure I was not harassing him. I advised Samuel he could check the car after the traffic stop was completed. Though visibly upset, Samuel complied and returned to the inside of his car. I conducted a records check of the plates for the vehicle and Samuel's driver's license through DOL, Department of Licensing, via my MCT onboard computer. Samuel showed to be suspended in the third degree. I issued Samuel a criminal citation for driving while suspended, third degree, RCW 46.20.342 sub 1C, and provided him a court date to appear in front of the Yelm Municipal Court on January 19th, 2023 at 1300 hours. I returned to the Elantra and provided Samuel with his criminal citation and advised him when court would be. Prior to driving off, Samuel made the comment that he knows my chief, then quickly left. Samuel was cited and released. Some or all of this incident was audio and video recorded. I certify under penalty of perjury under the laws of Washington that I have completed this in Yelm, Washington on the date above. The foregoing is true and correct, and I am entering my authorized user ID and password to authenticate it. Signed, Officer J. Murphy, Yelm PD, number 3996. So that's what the officer said. And that's just what he said. Now, do you have a response to that? And that's what I'll hear at this point.
All right, so this is what I want to say. I don't want to make a big thing of this, but I'm about to, and I don't know the chief. I've had encounters like this before since I've lived in Yelm. And I was bringing it up to him because, I mean, he didn't cite me for anything, which means I know my lights weren't bad. When I asked him to see it, he refused to let me. I did get out of the car to see it because we weren't arguing. I wasn't being anything. I stopped for him as soon as I seen it, so I didn't see him. I'm 4 houses down from my house. On top of that, if you can look at my license or where he stopped me and what happened. I operate a small business in this city, like I said before. I drive around here. After I got this ticket, I checked into it and found out they did suspend my license. The end of November. I was not aware of it. I did not receive documentation of it. I wasn't purposely just driving around, joyriding in my car. I was unaware that I had a suspended license. The reason why, because I heard what the prosecutor was trying to do for me, is that I'm indigent. I have no income. My business failed. I mean, it's the reason why I couldn't pay my child support. I'm 50 years old. I have 13 kids. I've never had a problem with child support. I've never had to navigate these waters. So I was just asking, the court to recognize that I don't have a criminal record. I don't have violations. If I was aware of it, I wouldn't have done it. But I choose offensive to how the officer wrote the report, because if he did activate his camera, I mean, I would think that would be falsifying the report because the incident did not occur the way he stated. But I don't want to make a big thing of it. I'm just saying, when I spoke to you last time, it was just, I don't have the $250 to pay. Whether it's in installments or not, I have to catch up on the child support. I mean, that was my only thing, Your Honor, but I mean, they know me by face, including that officer. I mean, that's the ridiculous part about it. And it felt like I was being baited because of the way he's writing the report now. It seems to me that he felt threatened, and I'm trying to figure out how could you feel threatened if you encountered engaging me, which seems to be the problem with the system to this day, because I was asking a legitimate question. Why did you stop me? And he said I was being confrontational, and that's not the case. I have the right to ask, why are you stopping?
No, he told you why he stopped you. Let me talk about the first. He said you tried to get out of the car and wanted to check on his lights. That was a traffic safety, officer safety issue. Get out of the car, his car going by might hit you, or that's it may pose some sort of a threat to the officer. It's when an officer stops somebody, it's pretty standard practice for him. Hey, stay in the car.
But not to leave him parked in the middle of the street. So how could it be a safety issue? Because we're in the middle of the street when he conducted it. He got out of his car. I stood in my car until he approached me and then said, "Oh, your light was out." And I was like, "Well."
He said he stopped you for two reasons. Either one would be a sufficient reason to stop you. But he also stopped you for, failing to signal a turn, going around a corner. That does, that gives him a reason to stop you. And what I need to do is determine, based on the evidence that I have in front of me, whether your license was suspended or not suspended at the time. And I don't hear any defense to that, really.
I was unaware.
It was, with regard to that, there is no requirement of the law that you be personally served or that you have to know. The Department of Licensing, all they have to do is send you the notice of suspension. Now, it may have gotten to you, it may not have, you may have moved. I don't know.
Like I stated last time in court, I'm not changing my statement like the officer is. I'm just explaining to you, Your Honor, that my past doesn't matter, but what the officer says goes. And as you can see from my record, I am not a person to be obstructive of any type of law. So if I was aware of it, I wouldn't have broke the law. I get it that you said you're not required, but what about if the mailman put it in the wrong mailbox, which we're thinking happened? I am being wronged for it, and then I'm being, I mean, whatever you have to do, Your Honor, I'm not trying to be argumentative, but you have to understand.
No, you can
Just from my point of view, and I'm not, even though you listened to what I said, I just feel that I'm not being given the benefit of the doubt that, you know what, things could have went wrong. You know what, he could have been really aggressive with the police and it could have turned into something else. It didn't. I was just simply trying to find out why I drove here going on 10 years now, Your Honor. It's easy to go past 35 miles an hour. It's the highest speed limit they have in the city. I've never done it. I towed a trailer. I'm just saying that, I mean,
I know what you're saying.
Whatever needs to be done, I don't drive anymore. I get it. I see it. It's just that I just feel now, because of this, that I should be in danger because the extra additive that this police added to this report gives me ground to go back to his superior to point out that, I picked to come here. I wasn't forced to come here. Based on that, it would be a fair place, but as I'm seeing now that it's just not the case. I mean, Your Honor, you're very polite. I get it, but once again, I stand against a system that's designed to do what justice is doing, trying to get me to give something that I don't have. If I had the money to pay, I would pay it. I don't have the money to pay. I wasn't unaware that my license was suspended, but none of that matters. I don't get the benefit of the doubt. And, you know, I just feel that I'm not being judged by the same that everybody else is, because that same officer, see, I was in front of my house. If he was being just, he could say, Mr. Newman, I can see you just, your license just got expired. Maybe you weren't. I've been driving for 5 years like this. I don't see why the court can't see the oversight that, you know what, things happen like that. And you know what, I'll give this guy a break. I'm not coming asking for a break, but I'm wondering why it's not even being considered.
If it was me that had stopped you, you know, the officer isn't here to explain why he wrote you up instead of just giving you a warning.
And didn't write me a ticket for the infraction, which is weird.
Yeah.
Which is weird, you know, but it's what it is, John. I don't want to take it any further. I'm just pointing out to you the obstacles that I'm jumping over.
That's, you know, something I've said many times, and it's certainly, I think, true. Life is unfair. You know, if there's anything, yeah, I agree with you not driving. The aggression that I see on the road, the way people are driving towards each other, and just the general behavior. And you can't drive the speed limit without getting run off the road by somebody that wants to go twice as fast. You know, the fact that he cited you, that was what he did on the night and that was his discretion. As I sit here, my job is to decide whether you committed the infraction or not. And I really don't have any choice but to find that you did. With the officer, I could disagree with the officer, sure, but that's not my job. As I sit here, the only discretion I have is I could find you $250 or something. No, I'm going to reduce that to 75, and we'll set it at 25 a month. Do you have your license reinstated? I'm hoping you do. If you don't, if there is an issue with your license, if you're still driving, try and get it straightened out.
Right. Well, I will do it, but like I said, this is new waters for me. I'm navigating my deal with the child's. Is it way in Everett? So there's no office. It's not transferred. It's out of Everett. So in order for me to even deal with these people, I have to go way out there just to do anything, to go to court, because I'm trying to get disability right now. And my caseworker was aware of that. We had no problem communicating, and all of a sudden, you know, here we are. But I appreciate you, John. I don't want to hold up the court's time. I'm just very upset that it has to be this way, and it doesn't, but this is just the way it is.
Again, yep, that is the way it is. You know, and that's, you know, I'm not unaware of the officers. You might not believe it, but a great many years ago, I had hair that came down to here and a full beard, and they called us hippies, and a lot worse than that. And yes, I got pulled over. I don't know how many times. Not because I'd done anything wrong. Maybe I had, but it was just to check me out, make sure that I wasn't holding anything or up to anything that I was aware of that. I was, and that's just part of the unfairness of life. But I can't make a judgment as whether the officer should or should not have handled it the way he did. My job here is to
I get it, yeah.
to just
But I'll just say this.
Sure.
In argument of us not questioning officers gives them the ability that only you should have, because you're just, and all of them are not. Judges should be just. Police officers are ordinary people who have bad days, bad mornings, and make horrible decisions, and it's evident of it every day. But yet the laws are based around their word over.
Judges are the same. We have good days, we have bad days, and that's I've been in front of judges. After 50 years in law, most of it as a defense lawyer, et cetera, that's been in front of judges where I didn't think they were handling things the right way.
Right, it happens.
But that's the world we live in.
It is, sir. And I appreciate you, John. I'll try to get it paid as fast as I can.
That's what as somebody said in a movie a long time ago, deserves has got nothing to do with it.
Yeah.
It's just the way things are. Mr. Samuel, thank you. You take care of yourself, and I signed an order disposing of today's case. You can get a copy of that at the window right outside the courtroom and to the left. Take care of yourself. And with that, we'll go off record.